So much, Ria. It's good to be here this beautiful Thursday morning. And again, our table is full. President Tinubu has just signed in the new Electoral Act, and that has been stirring a lot of controversy. Well, sit tight as we dissect the issues in the next 30 minutes.
Yeah, good morning, Nigerians. And like she said, to discuss the new Electoral Act.
Yes.
TJ, what do you have for our viewers?
Well, let's take you into what we have for you today. As Nigeria steadily counts down to the 2027 general elections, a major legal milestone has just been recorded. President Bola Tinubu has signed the Amended Electoral Bill into law, setting the stage for what could become one of the most consequential electoral cycles in the nation's democratic journey. The new amendments are expected to reshape key aspects of election management, compliance, transparency, and dispute resolution issues that have dominated public debates since the last polls. But beyond the presidential assent lies the bigger question: what exactly has changed, and how will these changes influence the credibility, logistics, and conduct of 2027 elections?
From electronic transmission of results to timeliness for candidates substitution and stronger penalties for electoral offenses, stakeholders are already weighing the political and legal implications of the amended framework. Will this law strengthen public confidence in the ballot, or will it trigger fresh controversies? To make more sense on the legal depth and practical impact of this development, we are joined this morning by Monday Ubani, a senior advocate of Nigeria and public affairs analyst. He will help us examine what the amended electoral bill means for political parties, the electoral umpire, and Nigerian voters as preparations for 2027 begin in earnest. This is FCT Brief, and the conversation starts now. Nice to have you here this morning.
My pleasure. Thank you for having me.
Sir.
Yeah, President Tinubu has finally signed the amended 2026 electoral bill into law. That opens a new vista.
Yeah.
Now, what exactly does this say about the politicking and what burden is now on INEC going forward?
Yeah, the point is that the electoral process started immediately after the election of 2023, and after the judicial interpretation of the Electoral Act of 2022. There were this discovery of some gaps in the electoral framework, and then they decided that we need to correct it before the next election. One of which was the issue of electronic transmission, the issue of IREV, which the Supreme Court mentioned was not actually in the law of 2022, and that's why the application for invalidation of the electoral process of 2023 on the grounds of the fact that there was no electronic transmission was refused by the court because of the absence of enactment. So they now say we need to correct all that. So many other issues that they needed to correct. So happily, that law has been signed. Yesterday, and then the certainty of the framework with which to guide the process now is now known to everyone. And so we are still having some level of controversy, especially with the issue of electronic transmission. Of course, I want to mention it now that electronic transmission is now fully recognized by the law. It's now in the law. The issue of IREV is also recognized now by the law. The only problem people are contesting is the issue of the fallback option. In case, it is called force majeure in any contract. If you're enacting any modern contract, you expect some eventualities that you don't anticipate that may likely happen. So that is what the Senate, now said, look, yes, we agree with electronic transmission, but should there be a problem, what do we do? That is that fallback option that is actually raising the controversy. But the law has been signed. So what we should now be looking forward to is how do we ensure electoral vigilance, operational vigilance on the part of the people to ensure that whatever is elected at the polling unit is what is reflected at the collation center, because that is where the problem is always occur. Collation center, we have already cast and then announced at the polling unit. By the time the result get to the collation center, you have a different result entirely. So that process is actually what has triggered the debate we must ensure that what is actually done at the polling unit is what is reflected at the collection center. I hope I've been able to communicate.
Of course, and like you rightly said, where we have reforms is to, or why we had this reform is to strengthen the country's electoral system. And you also highlighted that, this entire process has been marred by a lot of controversy, mainly because of one clause, which is Clause 60, that has to do with the mandatory transmission of election results. Now, this has dominated, the entire discussion, taking away, attention from what truly matters in this amendment. Now, can you take us through all other amendments that, seem to strengthen, or that will strengthen the electoral process as it stands?
Well, I know that there was this issue of intention of amending the law that has to do with calling witnesses, where on the face of the documentary evidence is very clear there is irregularity, because the onus has always been on the petitioner who is alleging that there is electoral irregularity or that the result that was announced by INEC is wrong. Now you are the one to call the witnesses, because whoever alleges must prove. So Section 137 under the 2022 Act made a provision that if you have a certified true copy of the documentary evidence that shows irregularity on the face of that document, you don't need to call witnesses anymore. But the judicial interpretation of that section has retained the fact that you still have to call witnesses. That when you come and when you come and place those documentary evidence, maybe the certified true copy, that it is regarded as dumping, you still have to speak to it. If there are differences in the figures in whatever you are dumping, somebody still have to be cross-examined on it. So there was this intention, why don't we do away with calling witnesses, so many witnesses, knowing the timeline within which you have to prove your case is very limited. Calling all those witnesses will really linger and make it impossible for you to prove your case. Can we limit it to documentary evidence? If it's very clear on the face, why do we have to call? So I thought that that particular section would have actually received the acceptance of the legislators. I don't think it did. They are still insisting that witnesses must still be called. And so it's still a problem. So nobody is even talking about that section. People are really concentrating on the issue of electronic transmission. But I saw it, I raised an alarm when it was being, I said, God, I thought we would have sorted it out, so that by the time you have the documentary evidence before the court that shows irregularity on the face of it, why do you need to call a witness anymore? So that has not been sorted out. Then the issue of strengthening the political parties, I think there is controversy as to removing indirect process now. It is now direct and consensus. So the question is whether the legislators have the right now to, since the court says it don't interfere with the political party program or whatever manner with which they elect their officers. If you now insert in the law that it must be indirect, are you not directly interfering with the political power to do whatever they want to do by way of regulation? But then it is now the law that it must be by way of direct and consensus. So indirect is removed.
Now, SCN, do you think it is deliberate that some of these points you've just highlighted within here, that argument from the national, from the lawmakers, and we seem to have made a lot of statement about the electronic transmission. They didn't talk about the calling of witnesses. They didn't even talk about the breakdown of communication failure, what it really meant. They didn't talk about that. They didn't talk about some other germane things that can enrich our electoral process.
That's correct.
Do you think it is deliberate? Because in this National Assembly, you have both the ruling party and the opposition parties, and they were silent on these other arguments. Yeah,
that is a very important issue. That's why I did an article after the law was passed, and I said, look, the INEC has a lot of responsibility now on their hands to look at this law as passed and signed by the president now to do some level of clarifications, that will really help the entire process, because transparency is key. Yeah. If you leave some words ambiguous, you are confusing the courts the more, and they're going to have different interpretations. So why do we have to now go into litigation that doesn't have an end? So what is communication failure? That was left,
but it's beyond INEC to do that.
Yeah, INEC, they have to clarify.
They have the power to interpret what the law.
What guideline?
Okay.
The law recognizes the fact that you have the Constitution, the Electoral Act, and the electoral guideline of INEC. You know that these are the body of laws that guide the electoral process. So if there is anything that is ambiguous in any of the laws that has already been, because the law cannot say everything. The statute may not have to, but the issue of interpretation and guidelines now will clarify the position of the law. Of course, what is the mischief that they wanted to cure? The mischief that the people who wanted to cure is, look, this thing was not in the law book. Are you following me? We're now putting it into the law book. Then you now bring a proviso. That proviso now leaves ambiguity. So what do? You have to clarify what it means. At what point is communication failure, noticed? Who declares it? What is the timeline within which you can really say that there is no network? But if you saw what the Senate President said yesterday, he said something that is very, very germane. He said this issue of we're making so much trouble about electronic transmission, that is already taken care of by saying that immediately after election result has been announced by the presiding officer and then recorded in EC8A form, right? Signed by all the parties. The next position is that you now transmit. You may have a problem where there is network failure. It will not go immediately. But the moment you have transmitted, that one works both offline and online. Yeah. By the time you get to where there is a service network, it will drop. So if it drops, so what is the issue? We don't have any issue again. Are you following me? Because if you are now arguing that there's going to be a network failure, no problem. But make sure you upload. Immediately you have announced the result. By the time you get to where there is network sustenance, so you won't have any issue. It will drop. So even when they go to the collection center, this result also will be there. So all this, we are really not addressing. And I also gave an advice in another sister's television. I said, look, it is now that the political parties need to be a bit more vigilant. Employ agents that are educated, that knows the law, that knows educate them. Don't go and get an illiterate to be your agent, both at the collection and unit, polling unit. Get them that are educated. What people usually do is that collect all the polling unit results by the collection agent, from all the polling units. By the time you enter into the collection center, whatever you are going to sign there inside the collection center is what has been reflected and what is given to you. Because EC8A, the presiding officer submitted to the collection officer. You have a copy. The security agency have a copy. Then what they are now saying that the one that is electronic also will be looked at when they are now computing to see that there is no problem. So I don't see any much issue in this matter. If we really want the country to move forward, we have recorded some level of progress in this matter. We have made a movement. IREV now is not recognized. Transmission now is not recognized. The only problem was that proviso. But the proviso can be explained by INEC, what it means. So there won't be any issue.
All right. I'd like you to hold your thoughts because we need to take this quick commercial break now. Don't go anywhere. We'll still have more. Stay with us. First, we'll continue our conversation with Senior Advocate of Nigeria, Monday Ubani. Now, we're still talking this Electoral Amendment Act. And like you rightly said, a clause now eliminates indirect primaries for political parties and just leaves the option of direct or consensus. And we've seen in recent times leading up to this 2027 elections that, political parties are more in disputes, they are in courts for one reason or the other. Now, with this clause, don't you think this will give rise to more litigation? And what does this mean for internal democracy and democracy as a whole? Because, to conduct direct primary elections will need a lot of money. Not all political parties can afford that kind of money. And if you say consensus, it's not everybody that will be on the same page to agree with one candidate. So what do you think this might lead to in future? Would this reduce the number of litigations we see after elections, or it will give rise to them?
A lot of people have started to write. It is only when these things are put in practice you now begin to see the realities. And my happiness is that whenever we try an option and it does not work out, we have to change it. I don't know whether this particular position that is taken by the legislators will not engineer more litigation and more problem for the political parties, because the issue of democracy at the political level is very key, because this is the political platform that actually throws those we now have a right to elect to be our leaders. So getting it right at that foundational level is very key. Now, if more crises are being generated at that level, creating problem of the kind of candidate that will emerge for us now to make a choice, at the national election, that there's a problem. So it is already a law. It has already been signed, right? So what we do now is to be a bit more vigilant. What do we do to mitigate anything that would now create a prolonged litigation and confusion even at that level? But I'm saying now it's already a law. It's already a law, but it is when we now go into practice and see some of the problems that may arise, we now say, look, that problem, that particular situation you have provided as a solution does not, you can't stand, let's change it, So it's a way. It's a way they think that they will want to probably enhance democracy at the political party level. But whether it is going to work out is when we go into the field, and let it be in practice. And if there are problems, we can change it.
Yeah. If we take a look at previous elections,
yes.
Especially the last one,
yes.
where some parties actually embraced the aspect of direct primaries, because we had system where, because of your war chest, financial war chest, you tend to buy over delegates.
Yes.
And some even have been accused that, look, you just lock down your delegates in a hotel and nobody has access to them. They felt that, look, if it's democracy, let everybody participate.
That's correct.
So that it's open to everybody.
That's
so
right.
In the wisdom of the National Assembly, shouldn't we give it to them? That, look, they're trying to help that, look, candidates emerging in political parties should not just be determined by the money bags. Let every stakeholder choose who emerges as candidates.
Yes, as I said earlier, is when we go into practice of what has been just enacted and see the practical realities, they will now say, okay, maybe they are wise in what they have done. I agree with you that there are situations where the money bags will hide delegates. And then they even dollarize the electoral process, Sometimes you don't have access to them because you don't have the money and all that. But they now say it's all comers are fair. If you are a member of a political party, come and determine who becomes your candidate and all that. So maybe in their wisdom they have seen it. But it's only when this is put in practice, we now realize whether it is something that is okay at the end of the day. But I think there is a level of wisdom in whatever they have done. Give it to those you have elected to go and represent you. And that's why I look at those also who are really, shouting and all that. When you have elected them, you have now conferred on them the sovereignty to now, decide your fate. It is a social contract. You transfer that power to them. I agree that most times you also tell them this is what you want. But if in their wisdom, they have said this is the way we think in the interest of the country we should go. You follow them. And ensure that all the safety guards are taken care of and all that. So if it does not work out, we come back again to the table and say, gentlemen, this proposal is not working out. Can we change it? And that is what has happened. Remember with the issue of accreditation, we started with manual, from manual, PVC, now BVAS. There's this movement. So I don't know why they have decided to say, let's do it, direct and then consensus. If it does not work out, we come back to the table and say, this is not, we must also insert that indirect. It is better for us, So I think it's already a law.
Yeah.
My only thing is that let's look for a solution whenever there is a problem. Let's not, kill the system because the problem has arisen. Let's now look for a way out in order to mitigate the harshness of if the law is harsh, let's mitigate the harshness and see what we can do if it does not work out and change it. That's what I think.
Well, INEC's notice period for election has been significantly shortened from 360 days to 300 days. And in a country that constantly battles logistical bottlenecks and all of that, don't you think that this may lead to operational failure and disenfranchisement?
It's an intelligent question. For me, time is not on the side of INEC in this process that is already, I'm sure they have told you now election will be in January. Is it not?
Yeah.
But look, where are we now? This is February. In fact, February has ended. So I envisage logistic problem for INEC. The budget has not been passed. I don't think they have entered into engagement with suppliers because suppliers must, get this now. Then you plan these things and the training, the recruitment process, So already we're having problem in our hands. When I see people suggesting that we should go back and begin to amend the law again, where is the time? There is no time. So timeline is an issue. And I think already we have problem on our hands. But INEC have to really up their game. They need to go ahead. They have been conducting elections since 1999. So I think with the issue of knowledge, and all that, they should be able, because if they are hoping to do all the things they need to do based upon this timeline without planning before now, there's already a problem on our side and on our hand.
Yeah, and I quite agree with you, because INEC, their primary responsibility is to conduct elections.
That's correct.
And all that. And you don't wait on the last minute before you start planning.
No,
You've had history of doing this same thing.
Even from the last...
What have you learned over the years?
That's right.
Even if it is reduced to 120 like initially proposed, you don't have any excuse.
That's right.
You must give Nigerians the election.
That's right.
So I'm asking, is it that we're trying to make excuse for INEC? Do they have a reason to give an excuse that because it was reduced, that is why we can't do such things?
The moment you finish conducting any previous election, the last election, the next election starts, the planning starts immediately. Yeah. And Nigerians were saying it, INEC, you don't have to wait until 2026 before you begin to plan for 2027 election. Because we are going to have election, you already know that it's a 4-year cycle. So if INEC is now saying, we are having logistic issue because of the issue that the law was passed late or the budget, and no, they're supposed to have put in place all the structures, waiting now for the things now that will now make it complete in terms of funding, in terms of the law, so they shouldn't give us any excuse. But in Nigeria, people always wait till the last line, and then that time they begin to give you excuse. We don't have much time. INEC has no excuse whatsoever. But I think that the law now is in place. We have a legal framework where the budget session is on, and I think whatever that can be done in order to ensure that INEC has the finance in order to organize a transparent election next year should be done. We don't have much time. But whatever it is, INEC should not give any excuse, because they have 4 years within which to are prepared for the next election.
Well, the Nigerian Bar Association has raised concerns over provisions that could penalize non-participation. Now, my question is...
Who's non-participation?
That is the voters' non-participation.
Yes.
Now, instead of fixing insecurity and public distrust, which is the main reason for voters not turning out, don't you think that this would manufacture a kind of a legitimacy problem of the whole entire situation?
Is it issue of time now, or what?
No, the voter turnout.
The voter issue, if you remember...
That is to stifle the voters into, participating mandatorily instead of addressing the concerns.
There was this issue they wanted to make voting very compulsory. There was a bill that time. And Nigerians said, look, what we are saying, make the system let's have confidence in the system, build trust. Make it look very transparent, make it look like my vote will count. Then I don't need any persuasion. Just like I pay my tax, I will come out and vote. Exactly. That is very critical. And that's why most of them were saying, they want that mandatory transmission. Thank God it is there. The only thing they're having problem now is that proviso, because we operate with proviso more than it becomes the rule. Ordinarily, my brother and my sister, if we really have trust, and if we really love this nation the way other nations love themselves, like Chinese and Americans, and love their nation, what they want to do at any point in time is how to advance their country, not to kill the country. If there is love, if there is trust, we don't need to have problem with what the National Assembly has passed. Because why? The electoral umpire will do the right thing. You can only declare communication failure where there is one. If there is none, for God's sake, you will be truthful enough to say there is no communication, this must work.
So the burden is also on them.
Yes, they have to show level of love for the nation. The judiciary also must be up and doing in interpreting the mischief. What is the mischief that the law wanted to cure? So that we don't go back again, doing the wrong thing. So if you are doing the right thing I'm a lawyer and I'm doing the right thing, you are a journalist, you are doing the right thing, INEC official is doing the right thing, the police, everyone is doing the right thing. We don't need to, have problem in Nigeria. But the only problem is that we don't love the country.
Okay, just because of time, I want to quickly look at this. Some of these parties, their cases are still in court, and we have these days reduced to to 300.
Yes.
How do you think the court can really act fast so that they dispense with these cases in court? So that
Which of the cases now?
The Labour Party's cases.
The political parties.
Exactly.
Yes.
How can the courts quickly
the courts have been trying so much to give preference to electoral issues. If you remember, whenever election matter is in court, they will call you their matter first before your ordinary matter, contract and all that. So the issue of dispensing with those cases that are in court, in a manner that is expeditious is very important, so that we can know where we are. I agree with you, we don't have time. From 360 to now 300. So it's a lot. So if we really want to have an electoral system that is free, fair, credible, without much crisis, I think everyone now have to fall in line. The journalists, the INEC officials, the military, the police, everyone that has a role to play in our electoral process in Nigeria must all gear towards the right thing, and then making sure that we have next year. We don't have much time on our hand. We must do the right thing so that the credibility of the election next year will not be in doubt. Let me tell you, nations are looking at us, all the nations in Africa, to lead in example. Ghana had an election how many years ago, and it was credible. The South Africans have moved forward in terms of electoral process. Why is it that Nigeria, who is the giant of Africa, is not getting it right with the electoral process? For God's sake, next year is a litmus test. We must get it right. And INEC man, the INEC chairman, is somebody who is a senior advocate of Nigeria and is coming in the saddle for the first time. I have hope that God is going to give him the grace to succeed next year. And all of us will have a country we are very proud of.
Well, all eyes on 2027. We look forward to how things turn out. We must say thank you so much, SEN, for your time with us on the program. It's a delight always speaking with you. Thank you.
Thank you very much.
Thank you for being a part of our